Welcome. Thank you for joining us for the first part of Alumni Weekend. Special thanks to our panel and our moderator tonight. We're so thrilled that you could all join us from parts near and far, as far away as Alaska and Brooklyn and West Virginia and Boston. And so we're just thrilled you could be with us. So I'm going to introduce Brook, our moderator. Brook is a member of class of 1976. He first practiced locally in a small public interest firm, but couldn't avoid his attraction to the law school and its progressive students, moving from part-time positions to a full-time tenure-track professorship in the late 1990s. Initially focusing on teaching legal skills and articulating a theory of practice-based learning. Brook used his first sabbatical in 1997 to reinvent himself as a global health and AIDS activist, and now teaches negotiation, disability law, and a seminar on human rights, intellectual property, and access to medicines. Brook, you've been a treasured colleague for many years, and I thank you for doing this, and welcome to all the panelists. Turn it over to you, Brook.
Well, this is a great opportunity to greet friends who practiced as judges in our class. There are others, and of course in many of the other reunion classes as well. But let me briefly introduce each of our speakers, and then I'll introduce what our panel is about, and then let our judges take over and fill us in. So we have Honorable Carol Ball, Associate Justice, Massachusetts Superior Court, now retired. Carol served as an assistant district attorney and spent 10 years plus in private practice. She was then appointed to the bench in 1995 by former Governor William Weld, a Republican. She retired in 2015 after 20 years on the bench. She is currently on the board of the Committee for Public Counsel Services and enjoys traveling pre-COVID and following her beloved Red Sox, who have one more chance tonight.
8 o'clock. 8 o'clock.
Right, 8 o'clock. Okay. Secondly, we have the Honorable Isaac Borenstein, a visitor to our reunion classes from the class of 75. Also a Superior Court judge, now retired. Judge Bornstein served 16 years in the Mass Superior Court and 6 years in the Lawrence District Court. He has been teaching part-time and full-time for 35 years at a number of law schools, including his favorite, Northeastern. This fall, he is teaching first-year torts, and Introduction to American Law for international LLM students at Boston University, another fine law school. He maintains a limited trial practice and is quite busy as a mediator and arbitrator at the mediation group here in Brookline, Mass. Honorable Dana Fabe, a retired Chief Justice of the Alaska Supreme Court. Dana spent 25 years on the Alaskan Supreme Court and was the first female appointed to the court and the first female Chief Justice, and is now serving as a senior justice and has her own mediation firm. She is the past president of the National Association of Women Judges. Honorable Victoria Roberts was a U.S. District Judge for the Eastern District of Michigan. She was commissioned to the bench in 1998 by President Bill Clinton. She has now taken senior status, but she announced her retirement, I think, the day of the inauguration in January. But she remains quite busy with her current caseload. She has earned 2 of the highest awards conferred by the State Bar in Michigan. And so those are our honored guests, though all of us who are watching are also esteemed. So I don't want to hold our judges out as any better than any of our other alumni, but certainly have served distinguished careers. So our panel topic is Judiciary Under Fire. And I want to just frame it a little bit and then basically let the judges take over to the discussion. So people have been concerned about politics in the judiciary. And there's multiple meanings of those political, of what we mean by politics. The big P politics is partisanship in decisions and partisanship in judge selection. So that's the concern that many people have, is that the judges are being selected and actually judge their cases based on party affiliation more than anything else. The second meaning of politics in the judiciary are, let me call, mid-size political questions. Controversial decisions on hot button issues, and people wonder whether those are being decided also somewhat on a political basis rather than a judicial basis. The small p politics of judicial decision-making really involves the question of the influence of judicial philosophy and the question of where judicial philosophy comes from. Does it come from experience? Does it come from identity-based commitments and experience? So it's basically a theory of judging and a theory of justice that might come out of the life and lived experience as a lawyer of the people who become judges. And the question is, to what extent does a judicial philosophy differ from a political philosophy, which might be differentiated? Then there's the myth of neutrality. There's no politics in judging, that there's something that might be called absolute judicial independence in allegiance to an easily determined rule of law that kind of springs out of the text that judges have to refer to. But the panel is also going to talk about the extremes of politics, and I'll put those in two different categories. One is the kind of predictable political backlash that occurs when judges make decisions that people don't like. And in this case, the politics of response becomes a politic of attack on judges and their decisions. I disagree with you, you're a political hack, and you should be challenged. But then we now have a new extreme. It's not only happening now, but it's happening in an extreme way. I hate you. You're a politically motivated danger. You should die. We actually have judges who are now need protection from litigants and from political activists who really condemn them and seek to silence them. And then we have a further question, which is, what is the proper place of criticism of judicial decisions, including on a political basis, and whether and how judges can and should pay attention to that. So I'm going to open it up and just let each of our panelists make an initial statement on the question of what's your sense, based on your past experience and recent experience, of these tensions about politics and judging and the judiciary being under fire. And maybe I'll start with Victoria first and let you start us off.
Well, thank you, Brooke, and thank you everyone who is tuned in to hear about the judiciary under fire. I just want to start with talking a little bit about judicial philosophy, because I believe that everyone who takes the bench, regardless of their politics, tries to abide by a judicial philosophy, which requires that judge to first examine the facts of the case in front of him or her, requires that judge to decide that there is going to be due process to the litigants in the case, and that judge is going to apply the law to the facts as they unfold. And I don't think that any person who has become a judge is going to depart from that as a philosophy in approaching how to decide a case. But when we decide those cases, we can't remove from them the fact that we are human beings, that we have lived a life, that we have experiences, that we have beliefs, that we have been involved in politics, and that is all part of the judicial decision-making. But I think that philosophy is one that we all try to adhere to, and we cannot separate the fact that we are people. We have been told, criticized as being politicians in Black robes, and I think that that's really an unfair characterization. We are human beings, and we wear Black robes, and we bring to bear all of the experiences that we have had, and it makes for the variety in the decision making. And that's why we have appellate courts, and that's why we have the Supreme Court. to sort of reconcile those decisions. But as long as judges have discretion to exercise, that discretion is going to be exercised in different ways. And you cannot deny the fact that we're going to bring to bear in that decision-making process our own experiences. Brooke, you're on mute.
Dana Fabe, maybe you'll tell us next about your initial reaction to the question posed to you about your experience.
Well, I agree with Victoria that all judges bring their life experience to the bench. But I think that political views have no place for a judge in decision-making. And there are all kinds of biases, explicit and implicit, that we are constantly needing to identify for ourselves, look into ourselves to make sure that we're approaching a case in neutral gear. I agree that where, for example, there's an equitable consideration in a case, or there's discretion to be exercised, certainly our own definition of justice or what is fair may come into play in a decision on what is, in an equitable decision on what is required. On the other hand, I do think that in Alaska, we have the particular luxury of having a judicial selection system that where politics are really out of that entire selection process. It's a merit selection process. We don't go before the legislature. A short list is developed by a screening council, and the governor must appoint from that list. There is no campaigning allowed for retention unless there's organized opposition. So I think in many ways that gives judges in Alaska a particular freedom to approach a case in neutral gear without concern for the ramifications of the decision. Certainly, as a judge, many times I have ruled in a way that as a matter of policy, I wouldn't have made that policy, but that's not what the legislature decided, and it's not what the rules require.
Okay, Carol Ball, maybe you can jump in next and talk about your experience, at the trial court level in Massachusetts, which I think a lot of the people on the call may be familiar with.
I'm not sure. I mean, I basically agree with Dana. Anybody who's lucky enough to be on the bench well, Massachusetts is a lifetime appointment state, or certainly a non-elected judiciary state is extraordinarily lucky. And obviously the federal court, because obviously we all know that John Adams drafted the Massachusetts Declaration of Rights, our Constitution, and then went on to be one of the framers of the Constitution. And this concept of lifetime appointment, although it's now long and about story, but carried over to the federal Constitution. We're lucky because it's easy for us to say this isn't my belief, or to take unpopular positions based upon our interpretation of what the law requires. I am lately on the topic of judicial independence, though, taken with the larger question of many of us who pay attention to these things, which I think is probably most people on this call, of the speaking tour. What was it Hillary used to call this? Something anyway, where we got Amy Comey Barrett, we got Alito, we got Breyer of all people. Who else do we have making a tour and saying, "Oh, we're not political. We just have a philosophy. It's our judicial philosophy, not our politics." But as others have said, when the decisions you make always appear to come down on the side of your political appointment, politics, as demonstrated by the appointing authority, lately the United States Senate and Mitch McConnell, then I'm not sure I see a big difference. So I think people like us toil in the vineyard. Like state court, it's a real vineyard. Appellate court, like Dana, it's more sort of supervising. Federal court, like Vicky, it's much more comfortable with 2 law clerks, and but it's easier. But I think that the lower your level of review by the media, by national politics, the easier it is for us to do what Dana articulates, which is to decide the case based just on the facts and the law, and keep politics out of it the best they can.
Okay, Isaac Borenstein, jump in and tell us what your experience is.
So, I mean, I agree with much of what my colleagues have said. I'm going to add that for me, there are 2 levels of expectations about this. One is the expectation that people have of us, and the other is the expectation we have of ourselves. Because I know, for example, you know, I've been around enough that I know that the expectation when Carol Ball goes on the bench is the defendant is going to get a more fair shake, that she's going to be more.
Isaac, you know, they called me at Suffolk. I always sat in Boston at Christmas time, and they called me Christmas Carol. And the defendants would get out of the van in the van room and say, "Is Judge Ball here? Is Judge Ball here?"
and she was known as somebody that could move more cases than even I could. And I had a little bit of that reputation, Carol, also. But so that's kind of an outer expectation that people have of us as judges. And the other one is, what expectation do we have of ourselves? And I'll be honest with you, I never went on the bench on any case thinking this is how I, quote unquote, should decide it, because of either politics or because it'll be popular or whatever the reason is. I really never did. That was the expectation I have of myself. I'm going to call it the way I see it. And it may be, in fact, unpopular. And by the way, no surprise, the job comes with criticism. We are under fire because we are lifetime appointments in very important positions that make very important decisions. So we're going to be subject to criticism. But the expectation of the outer world about us sometimes comes out in gross ways, like the former president going public and saying, "Look what I did for Kavanaugh. I saved his position, and he can't even vote for me on cases that I have before the court." This sort of expectation that you owe your appointed governor or president something, or you owe a political group something. And I think that I just have not seen in Massachusetts amongst my colleagues, that we try to fit that outer expectation. And in me personally, I can tell you, never, not a single case, and I had a few controversial ones, did I go on the bench thinking, oh my goodness, I should decide it this way. You know, obviously, as we have discussed, there are cases where we have a lot of discretion, including still there's a few statutes that we have discretion to sentence people. Not everything is minimum mandatory. And Carol has a particular philosophy of sentencing about which I share a lot, which is there are too many people in this country in prison too long for too many things that they ought not to be in prison for, at least that long. And I take that on the bench with me as a judicial philosophy. It's not about politics. It's about a judicial philosophy regarding sentencing.
So let me pick up on a couple themes that have come from what you've said so far. So it's interesting that all of you in the first response focused on this, what I had called the small p question, which is a question of judicial philosophy, and admitting that judicial philosophy plays a role, and I think admitting that you can't unlearn your life experiences, you can't unlearn all of the social and moral commitments that you've learned through your life. And I have two, and then there's 2 questions that I have about that. One is that this, as part of that, that what is your sense of awareness of the political consequences of your decisions? That is, it's one thing to think about whether you're making them because of political consequences, which is different from the question about whether you're aware of political consequences. So that's to really say, you know, somewhat ask, you know, how much does the awareness of political consequences, you know, burden you to some extent, maybe not necessarily over influence your decision, but at least part of what you're aware of. And then the second observation from what you've said so far is we have heard of people using the judicial philosophy as a shield for review of what seemed like very partisan decisions, but in each of your statements, a defense of your own personal sense of how you judged. So it seems to be that judicial philosophy is a very malleable concept, right? A very malleable rhetorical device that can cover a big range and can be deployed to defend even overtly political decisions. So it's always, judges always warn us not to ask two questions at the same time. So you probably want to tell me to only ask one, but those are the two that I come, and maybe you will have different responses to each of them. So the first is political consequences of your decisions, how much you're at least, conscious of that as you make your decisions. And then what you think about this kind of the malleability of judicial philosophy as a cover for what may be much more over political decision-making. And we'll go in the same order we did before. Victoria, we'll start with you.
I think that Isaac sort of touched upon a view that I have, which is that he doesn't make decisions thinking about what the political consequence is going to be. And I can say that, I've had some very charged cases, and I don't think about the political fallout of the decision that I'm going to make. And I don't think that it's because I have a lifetime appointment, I can't be voted out of office. I just strongly, strongly believe that there simply isn't a place for me in my decision making to think about or to consider what the political fallout is going to be. We're supposed to be an independent branch of government. That independence isn't completely there because we get, at least at my level, the executive branch has to nominate me, and the legislative branch can remove me from office if I do anything that is impeachable. But in between that, I really do believe that I enjoy an independence that is, and my decision making is supposed to reflect that independence in everything that I do. Is my judicial, have I ever thought that my judicial philosophy is so malleable that it's a cover for politically charged or the kinds of decisions that I shouldn't be making? I've never thought that, but I do understand and I do respect that depending on who that judge is going to interpret facts very differently from another judge. That judge is going to interpret the law very differently from another judge. But I would never describe that as malleability. I describe it simply as the role of a judge and what I am supposed to do and what I'm only capable of doing, which is to make the decision based on everything that I have available to me, which is my experience, which is my common sense. I read an article recently where a Black judge was describing a conversation that he had with one of his colleagues who had an employment case, and that white judge was questioning the facts in that case where the plaintiff said that a noose was left in the locker room and nigger was painted across the wall. And that white judge couldn't believe and thought really that person was exaggerating the facts. I can tell you that most Black people that I know will not approach that case thinking that is an exaggeration, because we know that has happened. We have parents who came up from the South and it happened. We know that it happens. So I think that so much of it, again, depends on the lens through which we have lived our lives and the lens through which we make our decisions. And I don't think that we need to be apologists for that. We have the benefit, I think part of our independence is checked by the fact that we bring in juries who are the fact finders in many of the cases that we have to decide. And we want to assemble jurors who are different, who are diverse, who have all sorts of backgrounds, and who can come together in a room and make what is generally a unanimous decision. And so it is a respect for diversity in backgrounds and how important that is in making decisions that impact the lives of so many people. And just one more point I want to make, we have jurors, we have 12 jurors. On our Supreme Court, we have 9 justices, and we like to focus more on the fact of who appointed those justices and the decisions and the 5-4 decisions. I think a lot of people would be surprised to know that so many of the decisions that the Supreme Court renders are unanimous decisions. In the 2021 term, for example, 67% of their decisions were either unanimous or they were 8-1 decisions. And in the 2016 term, 57% unanimous decisions. So those are judges who have so many different backgrounds, appointed by so many different presidents, and they somehow manage to make unanimous decisions, just like the jurors make unanimous decisions all the time. It is an acknowledgement of the diversity of backgrounds and how important they are in decision making. And I would never apologize for the life that I have led that is reflected in the decisions that I make.
Okay, and just one quick interjection before I move to the next person. By political consequences, I didn't mean political fallout or political assessment of the decision. I meant more the social impact, the social political impact of decisions. And so I would like people to at least reflect on that interpretation of what I meant by political consequences. So let's call it social impact consequences. So Dana, maybe you next.
Right. Well, again, the Alaska Supreme Court reviews redistricting decisions. It reviews ballot challenges. We're in a small state where often an election is decided by a vote or two. So if there are challenges to a couple of votes, it can change the outcome of the election. So those might be examples of cases where our decisions have real political consequences. And I can tell you, I cannot agree more with what Victoria said, because in making those decisions, which have involved not only national races, political races, but local political races in our state, you're aware of it, but you can't pay attention to it. In other words, it's not that you are not aware that whatever you're doing is going to have a real impact, just as judges are always aware that their decisions are going to have an impact on the people whose cases are being decided. But even those cases that are highly political, I think a judge's job is to tune out that piece of it. It's almost like diving into the pool and you can hear the voices on the surface, but you're underwater where you need to be in order to make the decision. And I also think what Victoria said about the jury versus comparing a jury to an appellate court is very perceptive because I was on the trial bench for 7.5 years and on the Supreme Court for over 20 and still serve on the Supreme Court on occasion and as a senior justice. And I can say that we have all come from different backgrounds on our court. I served with many different justices over that term of over 20 years as an active justice. And there were different personalities, different philosophies, and yet most of the time we reached consensus because we were all trying to put aside what wasn't relevant to the decision and focus on what was. And when you talk about judicial philosophy, there are a lot of different ways to look at that. I would say looking at a defendant, I've sentenced defendants, and determining whether or not they really need to be isolated as the primary goal or whether rehabilitation is the primary goal isn't so much a judicial philosophy, it's doing your job and exercising your discretion. But I think politics certainly have no role in that decision-making process. And the last thing I'll say is there is an aspect of the impact being the response to your decision too. Alaska, although we have a merit selection system, the voters get to decide every so many years, depending on the level of the court, whether to retain you. It's a retention system. The Supreme Court justices serve every 10 years, are on the ballot every 10 years, with the voters saying yes or no, no opponent, no campaigning unless there's organized opposition. And I made decisions I went through that retention process twice on the Alaska Supreme Court. Both times I had active opposition because of decisions that I had either made or participated in or authored, mostly involving abortion. But even then, you have to not be cognizant of that, or at least not focused on it when you make your decision. You have to do it without fear of reprisal. You have to do it based on what the law requires.
Brooke, if I may, what I'm also hearing, and I'm curious to see how my colleagues react, when Chief Justice Roberts said in his confirmation hearing, we are umpires, we only call balls and strikes, which seems to me to be perpetuating a myth, because I don't think we're just calling balls and strikes. I think we're doing a lot more than that. And maybe people don't want to talk about that, because of what it raises. By the way, I was an umpire in Miami Beach many years ago, probably the most dangerous job I ever had, being an umpire in Little League. I barely got out alive after every game. I'm sure that's not what Chief Justice Roberts meant.
So let's get Carol.
Yeah, if I could
Say
just say, I certainly agree with the aspirational statements that when you go on the bench, politics have nothing to do with it, and you're aware that there's going to be a response, but you're underwater and people are talking above your head. Obviously, that's the aspiration I think any well-intentioned judge has. And I think by and large, most judges achieve that. I certainly don't think it's uniform in any given state, once more nationally. And I also note that there's a lot of ways politics can creep in other than in the substance of a decision. In other words, deciding a case the way you want to, as opposed to what the law and the facts dictate. And by that, I mean, once you make a decision, the way you phrase your decision, timing is one thing, how quickly you're going to act on something and issuing an injunction or not. More importantly, the language you use in your decisions. I really was taken aback, philosophically, I agreed with it, by the district court judge in Texas, who, when the Justice Department filed suit about this Texas bill, that the Supreme Court today just said that they would give hearing on, it's a standing thing, as best I can tell, on November 1st, in a week and a half. The district court judge went out of his way in his decision, as I think many of us have in a decision you feel strongly about, to blast the point of view that the Texas law is constitutional, at least based upon Roe v. Wade and Casey versus Pennsylvania as it stands today, October, what is it, 21st? There's my camera. As it stands today. And he went out of his way to use language, and it's very easy to use language that's not explosive, that was immediately reported in the Times, the Post, and all these things, because he felt so strongly about it. But there are a lot of ways, as I say, judges can use their voice to enhance or decrease the political impact of decisions they make. Just saying.
Victoria, it looked like you wanted to jump in.
Yeah, I want to just respond to Isaac and the umpire who we call balls and strikes only. And, there may be some truth to that, but I think we have to recognize also that, there is a strike zone and there's a ball zone. And within that zone, we're all operating. And that's why you see review of footage all the time to make sure that the call is the correct one. And sometimes it's a close call. And I think it gets back to the point that all of us have been making this evening, which is that we have discretion. We have a strike zone within which we can operate. how many decisions talk about reasonable minds can differ? Well, that's exactly what we're talking about. Reasonable minds do differ, can differ, should differ. And that's why it is so very important for us to have diversity on the bench. President Trump appointed almost 230 people during his 4 years in office. The vast majority of those people were white men. They were white and they were white males. And, you know, a number of people asked me, even though I was able to take senior status before the time that I did in January, why didn't I do it during the Trump administration? Well, I didn't do it for that very reason, because I didn't trust. I knew that the Federalist Society was very involved in making recommendations for people who should go on the bench to the president. So you had one organization completely impacting who got on the bench during that administration. You had a president who bypassed the ABA process, and only Trump and I think George W. Bush in modern day presidents have bypassed the recommendation of the ABA in appointing federal judges. So, you know, having that track record, it became very, very important to me not to give President Trump another seat to fill, because I didn't trust that he was going to be mindful that it is important to have diversity on the bench and have federal judges who look like the people that they serve. And so I waited, because I had more confidence that President Biden would do that.
So I want to raise the heat during our last 5 minutes before we open for, in this sense, part of the reason the panel was titled this way is that the political response to judging has become much more vicious and in fact dangerous. And when we spoke, you know, earlier about some of the experiences that all of you have had, that became clear. So maybe people could talk about not so much the question of whether judges are political, but whether judges are perceived as political in the big piece sense from both sides, you know, from both sides of the political perspective, and much more at risk because of the decisions that they are necessarily have to take, you know, in our current system. So maybe Isaac, I'll start with you because you only got a couple minutes.
I mean, I have to tell you about the January 6th attack on the US Capitol. The Supreme Court is only a block away, and it occurred to me that I'm surprised that building was not attacked physically also. And so I do think judges are much more at risk now with threats of physical violence because of politics. And actual carrying, a number of judges have been assassinated, or their family members have, in a way that I think has increased dramatically over the years. I never felt any personal threat on the Superior Court, although I had one incident of somebody showing up at my house on a Sunday, but she was non-threatening. She was scared because her father was about to be sentenced, and she was so distraught that she thought I might be able to help her. In fact, I convinced her that approaching me would only hurt her if anybody knew about it. But I've never been personally threatened. I know many judges have now and require protection. So there's been an escalation. It used to be, the word used to be judges and even prosecutors and defense lawyers are not to be attacked. Well, that has now gone out the window, I think, and there are real threats to the judiciary.
Dana, I think you described some of your experience in this regard, and also Victoria, as I remember.
Right. Well, you know, I think I have been threatened personally, but it was a domestic relations case, and a party who was upset with when I was on the trial bench with rulings I made. And that was back in the late 80s, I think. So I'm not sure that's any different. I will say that there was a website that had little targets on legislators, judges who were viewed as unfriendly to those who opposed abortion and abortionists, and that had blood on it. And the U.S. Marshals came to visit me in my chambers to let me know I was on that website and to be careful about how I went out to my car, and they had me change my parking space. So it's something I think that all judges face, but it's not simply because of decisions that are political in nature or political anger over decisions. I think it can happen in domestic relations or many other cases that are incendiary. But here's what I will say, though, is that I think there is a movement around the country started by Kevin Burke, a judge in Minnesota, and Steve Lieben, an appellate judge, on the importance of procedural fairness and how, and I think Carol touched on this, how you communicate your decision. And I think Victoria did too, listening, being respectful and allowing people to have their say, and then explaining the decision in a way that's understandable, that explains the process as well as the substance of the decision, is really quite critical in having people accept your decision. And I think probably all of us on this panel have had the experience where someone in front of us, particularly on the trial bench, who was ruled against says, well, I think I got a fair shot just because of the way they were treated. And so I think that is a key to de-escalating some of that anger.
Vicki, maybe you and Carol can finish this off for us.
That the decisions made by judges in the vast majority of cases are accepted. The legitimacy of them are accepted, even when people are on the losing end. What is very frightening to me is that we have these handful of cases where judges have been murdered, their families have been murdered. And the January 6th uprising, I think, was probably the biggest incidents that I can think of where there was just a rejection. There was a rejection of over 60 decisions across this country. That election was legitimate and it was fair. Nonetheless, we had all of these people converging on Washington, and we had deaths that resulted. And so it is frightening that there are segments of the public that will not accept the legitimacy of decisions made by judges. And that's what we have to, I think that's what we have a responsibility to work on. How can we get people to accept? How can we get them to understand that the decisions are not political, that they're not intended to harm, that just because you're on the losing end, it doesn't mean that you can take up arms. So the legitimacy of our decisions, I think, really do, it's a matter of public education, I think, and there's a lot that can be done in that arena.
Carol.
I think the horse has left that barn. Education. I think the reason the problem, I think the judiciary has been infected just the way the legislature had, the legislative branch has, by politics. And it is perceived by the public that the courts are political because of what has gone on. And in fairness, I mean, I don't know, in my lifetime, it started with the Warren Court being, in all these rights. I mean, in other words, I don't mean it was bad. I'm saying the Warren Court was a progressive court that in Miranda, all the search and seizure stuff, and that alienated certain segments of the population. And now we're in the other direction. And now the court appears to be completely political. And to say that we're fine, we really, no judge intends to harm anybody. They're just doing what they think is right. Let's talk about that when the Supreme Court decides to overturn Roe v. Wade, which is going to happen pretty obviously, it seems. And it's the Supreme Court itself who I think has made itself increasingly, who has contributed to this politics stuff. And they have nobody to blame but themselves, hence the talking tour as opposed to the listening tour that they're going on. Anyway, that's my feeling.
Okay, so thanks so much. We did promise people who've been listening who have lots of insights and questions. And we're just going to open it up and let people raise hands. We've seen some in the chat box, but I'd rather have people express their opinion themselves. If you can push the little reaction button at the bottom of your screen and raise your hand, and we'll go in the order of the raised hands. Okay, it says Maljman. You're on mute.
You're on mute.
Unmute. Hi, it's Michelle Allman.
Okay.
I'm curious whether you think that it's time to revise the lifetime appointment situation in order to address some of the politicization of the judiciary. I live in Vancouver, British Columbia now in Canada, but I was admitted to and practiced in Washington State after leaving Massachusetts, where I grew up. So I've experienced the three different approaches to how judges hit the bench. One is the Massachusetts lifetime appointment, Washington State campaigns, which I found totally bizarre. And Canada and British Columbia, it's more like the ABA recommendations. But I have to say, those are political too. So it's just like the Federalist Society's, entree into the recommendations or nominations process has been. So I'm wondering what you think of the notion of reducing the lifetime appointment to something long enough to withstand political winds that are momentary, relatively speaking, versus enshrining a seriously conservative or a seriously, quote unquote, leftist approach to law.
We'll take a couple questions. Steve, you have your hand up too.
Yes, I have a more systemic question, which is, in my experience, has been that very little has changed in the justice system, particularly the criminal justice system, since we graduated. It's still biased and against poor people and people of color. It's absolutely obvious to anybody that practices law. To what extent do you think that the judiciary is responsible for this?
Okay, and we'll take one more from Jim Crane, and then we'll open it up for our panelists to respond to the three questions.
You're mute, Jim.
Sorry about that. First of all, hello, everybody. But I'd like to hear what the panel's thoughts are on the proposals to increase the membership in the Supreme Court, perhaps either by itself or combined with the notion of putting in term limits.
Okay, so let's try to have relatively quick responses to these so we can get another round of questions. So who wants to go first? On the panel.
I'll take a moment and tackle Steve Saltonstall's question. And nice to see you, Steve. I don't think I've seen you since graduation. And I agree with you that the criminal justice system is incredibly biased against minorities. And part of that, at least at the federal level, is because Congress didn't let judges be judges. One of the biggest problems are the sentencing guidelines and the mandatory minimums. And so the kind of discretion that we've been talking about, the judges should be able to exercise for many, many years, we didn't have those. I didn't have them when I went on the bench. It was required that I follow those guidelines. And so even though I wanted a different outcome, didn't want to send anybody to prison at all, was not able to do that. We see that gradually changing, but it certainly hasn't changed enough. And it's just been very, very slow. But I think when we can use guidelines and when we can take into account the entire person in making sentencing decisions, I think that there will be some progress there.
But I think judges, I agree with what you're saying, Victoria, but I do think the judiciary has responsibility too. And actually we brought Dr. Kimberly Papillon, who does a training on implicit bias, as well as Judge Bernice Donald to Alaska, because I think judges, although they may be sincere in wanting to not be biased, there are biases that judges may have that they're not even aware of. Looking at two different defendants, and if they identify more with one in terms of their background or race, that may have an impact. So I think I agree that sentencing here, it's presumptive sentencing, has tied judges' hands. But on the other hand, I think the judiciary has a real responsibility to not only train once, but keep up that training of judges on the implicit biases that they may have.
Can I also address that issue? Because it's not only a problem in the criminal justice system. I'm teaching torts this fall, and I found a textbook that actually addresses in a serious manner the biases in the tort system, both racial, gender, and income bias, and the way damages, for example, are awarded to people, and the kind of considerations that who is the reasonable person when it comes to damages, and how you project damages for lost earning capacity into the future. So on the civil side, there's also a lot of things that judges are doing around the country. Jack Weinstein in the Eastern District of Brooklyn in New York has been a hero of mine for years, because he's done a lot of work taking on these kind of issues and doing something about them, both on the criminal and on the civil side. And there are judges around the country doing it. In fact, in Massachusetts, the last 3 or 4 years, the SJC, before Jerry Hines left the bench, unfortunately, made decisions about, is flight by an African-American young man reasonable suspicion of criminal conduct? And the SJC said, not necessarily, and we are basically giving a license to trial judges to consider the reports in Massachusetts about the bias that shows up in stop and frisk detentions. So there is some progress by the judiciary. We need more judges that are gutsy like that, that are brave, that are willing to go out on a limb. And for the most part, I don't see that. I'm glad to hear that that kind of training is going on, Dana, in Alaska. You have to have judges willing to be trained and to listen to this in order to do that. So there is a lot of work to do. I appreciate your question, Stephen. In terms of appointments, I think every system has its flaws. I would rather a system with lifetime appointment and its own flaws than a system of election or merit retention to make it a little cleaner from politics and campaign contributions and the like. So I'll take the appointment system, even a lifetime. Although, you know, let's be careful. It's not lifetime in Massachusetts. It's to age 70. And I reject the idea, by the way, that 2 of my colleagues are on senior status. They are of an advanced age status, not senior status. I don't call it senior status anymore.
Okay, Harry Daniels has very patiently been waiting with his hand up. Harry, why don't you ask your question?
You're mute, Harry.
Judge Bornstein touched on what I was going to raise, but that is, having spent my entire career on the civil side, I wanted to hear the panelists comment on some of the concerns about bias and the danger of discretion, I think, on the civil side, especially when it comes to things like Judge Roberts was mentioning the reaction of a white judge to an employment discrimination plaintiff's recitation of facts that would be very different if Judge Roberts were hearing that. And I dare say if the rest of our panelists were hearing that, but I wouldn't expect the reaction to be very different if a Trump appointee were hearing that. And I'm curious as to whether people have seen as much concern about the bias or potential for bias on the civil side, as we have seen on the criminal side. And Judge Bornstein, I'd like to get I will do it offline, but I'd like to get the title of that textbook.
Yes, it's the only textbook out there that I've seen take this on seriously. And Harry, where I have seen it is the way economists come in and testify. What is the average income of a white male or an African-American male or a woman, which typically would be less than the average white male, but that's what the jury is told that they're supposed to use in calculating loss of earning capacity, for example. Or what if a child is injured permanently? And sadly, on the Superior Court, I've had cases of children that are injured at birth, and jurors are told to calculate damages based on their family background, how far did their parents go in school. And so if they've had an economically deprived background, the jury is basically told you can use discriminatory basis to come up with a damage award.
And we see it, and we see it in wrongful, and except for the widely publicized cases, we see it in wrongful death awards.
Absolutely.
Consistently, I believe.
African American and Latino lives are worth less. Lower income are worth less. Women's wages are worth less. But judges are beginning to change that. And my students, by the way, were shocked at some of the discussion that was raised in this casebook and some of the cases. But I'll be happy to share that with you, Harry. The casebook was a surprising development for me that I caught it.
I'm curious to hear Judge Fabe, and I think I know where Judge Ball is. I don't know Judge Roberts, but I have a feeling I know where she is on this as well. But I'm interested in hearing the comments of the other panelists.
Well, I think you raise it's a subtle point, and I don't think a lot of focus has been given to it, and it's actually really a worthy one of probing more. So I may call our judicial education people to say that the next, again, we are committed to doing the implicit bias training on an ongoing basis, and it seems like a really good focus for a future training. So thanks.
Not only that, but model jury instructions need to be, I mean, what Isaac brings up is absolutely a valid point, but there needs to be a work on model jury instructions for things, that kind of issue. I mean, the stock instruction is, consider their education, consider what their future life, income would be, income potential. What is it? I'm so glad I'm retired. I can't remember the lingo anymore. So
life expectancy too, which is racially differential.
Right.
And likely lifetime income. Right.
Yeah, no, the good news is there is implicit bias training. I mean, I know people in other states as well through trial advocacy teaching. They're doing implicit bias training across the board in most states, at least. Well, I shouldn't say that. I guess the states I know of.
Yes, the blue states.
Yeah, the blue states.
In some implicit bias training, they have used a picture of Snoop Dogg. We all know what Snoop Dogg looks like, and a picture of Martha Stewart. And they ask the people, which one is the convicted felon?
Right.
And between the two of them, we know that it's Martha Stewart, but Snoop Dogg gets chosen more often than not. And that can be the beginning of some very important implicit bias training in courts.
I had a number of white jurors in a murder case say to me, almost some of my best friends are Black. And then we asked, how do you feel about interracial dating? Oh, no. That I will not accept. I don't want my daughter going out with an African-American man. So if you ask the question, so jury selection is another place, right, that we can do a lot more work about.
So I always hate not to give my friend Liz Rogers a chance to ask a question. Can I ask if we have another couple minutes that we can go over to the organizer? I guess I'm kind of an organizer. Liz, go ahead. We'll cut you off if we have to.
Sure, maybe 2 more minutes, Brooke, okay?
Yeah.
I just wanted to say I am really interested in all the comments about implicit bias, and I would love to know what role lawyers are playing in jury voir dire, because we found that in Massachusetts, there was really good training and there was really good strategy in part of the strategic plan of the Massachusetts civil courts that every judge had to be trained in implicit bias. And then the judges allowed us to do jury voir dire. And once the plaintiff bar got educated in how to talk to juries and say, well, you know, how do you feel about interracial marriage? Or how do you feel about, you know, do you have any Black friends? Or what do you think about, do you think there are too many lawyers? Or what do you think you could give anybody emotional distress damages? And somebody would say, oh no, they're, you know, sexual harassment plaintiffs are just asking for it. And we got so much more information from juries once implicit bias started being recognized. And I wondered if anybody else had that experience of what are the lawyers doing to correct for implicit bias in your courts?
Liz, I for the first time, I had my first jury trial post-COVID right after Labor Day. And there was a motion made in that case to show the jurors an implicit bias video that has been produced by a federal court in the state of Washington. And I don't know if many of you have seen it, but I certainly would recommend it to you. It was met with some resistance initially from the U.S. Attorney's Office, but now our bench has looked at it, reviewed it, and although it's not going to be shown in all cases, if a judge wants to be shown, it's going to be shown to the jurors who will be sent to his or her courtroom. It's an excellent video.
How do we access it?
On implicit bias, and that court will give anybody permission to use it.
What is it being used in, like identification cases mostly? What?
No, it's being used in, the motion was made in a criminal case that I had, but it can be, it's universal. It can be used in any type of jury case, regardless, just to get them to focus on the possibility that there is a bias that could stand in the way of the right kind of decision making. The participating in that video is the chief judge of that court, the U.S. attorney, the chief federal defender, but it can be used in a civil case as well. It's actually,
Victoria, how do we access it?
I'm sorry?
How do we get a hold of this?
You contact, I think it is the Eastern District of Washington Federal Court, but I'll check on that and ask the clerk of the court to make you a copy.
Well, it's no surprise that these judges will not only talk about judiciary under fire, but judiciary being reformed. So we've turned, I think, strongly in that direction, and maybe we need to have a second, judicial forum, even for this reunion. I don't think we can squeeze it in, but I want to take this time to thank all of you. I think many of you will be staying on for our class of 76 reunion.
It's a different Zoom, Brooke.
I know, but
Okay.
just to hope all the judicial panelists will join the class of 76. And I think we need to sign off. Is that correct at this point? Do you want to say goodbye for us, Miel?
Sure. Thank all of you for participating, sharing your opinions and your thoughts. It's wonderful to have each of you sharing some of your perspectives over a fair amount of time from all different courts and benches. So thank you for being with us tonight. Thank you to the people that joined us from as far away as Australia. We hope to see many of you tomorrow morning, either in person or virtually. But just thank you for making time, and we appreciate all of you. Thank you, Brooke. You did a wonderful job of steering the car, so we appreciate it. Thanks everybody for joining in. Appreciate you.